Hey, everybody. Welcome back to the Court of Random Opinion. My name is Lauren Neidigh. Sorry, we'll get started in a minute. I'm just going to give people a sec to filter in here just because I know this is kind of random timing. However, it did just hit the docket. So I have not read this yet, guys. I'll be going over it for the first time with you. So bear with me. It's not a very long document, so no worries. I will say it looks like it was granted in part and denied in part. So what that means, we're about to find out. Just let me give it just. All right. And bear with me. Like I said, I'm usually doing this stuff on my breaks from work, so we'll go through this pretty quickly, and then later we might talk about it more in depth. Here we go. Yep. I do not think Court Listener has updated with this yet. Check it. Yeah, they haven't yet. It should be on there shortly, though. And I'll also post the link to this on my YouTube page under posts and on my Patreon page and on my Twitter page. So if you want to read the document yourself, you can always find a link at those places as well. The links to those are in the description of this video. So it's no wonder. Hey, how's it going? Stephanie, thank you for the 5. Always the first to report. Hey, I appreciate it. I know we've been waiting for this one, so. And since it came out early this afternoon, maybe I won't have to worry about anything tonight. If anything else comes out on the docket, then I will do a live tonight. If not, then I won't. I'll just take the night off. But remember, guys, also a week from today, a lot of these filings are due. A lot of the responses to the complaints. So we're going to see lots of stuff probably coming out in the next week. Unless the dates change, but I don't think they will. All right. Let's get going, shall we? Blake Lively, Ryan Reynolds, Leslie Sloan, and Vision move pursuant to Federal Rule of Civil Procedure 26C for entry of a protective order. Wayfair Studios, Justin Baldoni, etc. consent to entry of the court's model protective order, but object to any proactive or protective order permitting attorney's eyes-only designation. The court held argument regarding the proposed protective order on March 6th in this case, and in the related case, Jones versus Abel. Plaintiffs in Jones versus Abel seek entry of the moving party's proposed protective order, and defendants object for the reasons stated by the Wayfair parties in the related cases. For the following reasons, the moving party's motion for entry of a protective order is granted in part and denied in part. So same with the subpoena issue. Remember the judge's ruling on that. They granted in part, denied in part. So let's see what that means. The court will enter protective order with a modified attorney's eyes only provision and certain other modified language. The court will enter the same protective order in the related case, Jones versus Abel. The Supreme Court has held that it is necessary for the trial court to have the authority to issue protective orders conferred by Rule 26C because of the liberality of pretrial discovery permitted by Rule 26B1. The federal rules of civil procedure provide for broad discovery of information for the purpose of assisting in the preparation and trial or the settlement of litigated disputes. While necessary, liberal discovery also allows extensive intrusion into the affairs of both litigants and third parties. And much of the information that surfaces during pretrial discovery may be unrelated or only tangentially related to the underlying cause of action. This creates a significant potential for abuse. Litigants may use the discovery process to obtain, incidentally or purposefully, information that not only is irrelevant, but if publicly released could be damaging to reputation and privacy. Discovery involves the use of compulsory process to facilitate orderly preparation for trial, not to educate or titillate the public. Federal Rule of Civil Procedure 26C addresses this issue by allowing a court to grant a protective order to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense in the discovery process. The burden of showing good cause for the issuance of a protective order falls on the party seeking the order. A protective order may require that certain material obtained in discovery be kept confidential or disclosed only to attorneys. Notably, the latitude that the court and the parties have to protect information during the pretrial discovery phase does not extend to court filings and to the trial phase after discovery has been winnowed down to that information, which is truly necessary for the decision in a case. Then, the public and the press have a qualified First Amendment right to attend judicial proceedings and to access certain judicial documents. And guys, assuming this does go to trial, I will probably go to New York and try to attend, if that's possible. So we'll see. I know there's no like filming or anything like that in federal trials, but I would like to go. The parties have agreed to the entry of a standard protective order allowing any person producing discovery material to designate as confidential financial, business, and personal or intimate information, the disclosure of which would cause harm to the producing parties and or to a third party, I think we know who that is, to whom a duty of confidentiality is owed. There is good cause for the entry of such an order. Each of the Lively and Wayfarer parties have filed claims against the other. Jones, the owner of a public relations company, has filed claims against her former employee Abel. The parties have leveled accusations of theft of trade secrets and the disclosure of confidential sensitive information against one another. Discovery will inevitably involve some amount of sensitive business and personal information, the premature public disclosure of which could cause harm to the producing party or to a third party. Okay. And then he's citing a case here that says, noting that all members of society should have access to a fair and impartial judicial system without having to pay too high a price of admission in the form of the surrender of personal privacy. Okay. The parties part ways, however, on whether the protective order should include an attorney's eyes only provision. An attorney's eyes only provision allows certain information produced in discovery to be shared only with lawyers for the party receiving discovery, not their clients. The moving parties argue that an AEO provision is appropriate because of the risk that sensitive details revealed in discovery will become weaponized by the parties in the media, chilling third parties from producing discovery, and imposing an impermissible tax on the prosecution and defense of legal claims. The moving parties specifically note the potential harms to third parties who could have private and sensitive information spread through the press as a byproduct of this litigation. The Wayfarer parties respond that Lively has already disclosed sensitive personal information related to her alleged harassment. They suggest there is no need to presumptively designate material AEO at this time, and any need for material to be designated AEO can be determined as it arises. The moving parties have shown good cause for a limited AEO provision and have shown that entering such a provision now is critical to the just and speedy, if not necessarily inexpensive, determination of the case. In particular, the disclosure to the parties of certain information that will invariably be exchanged during discovery, but which may not be necessary to the prosecution and defense of the case, presents an incremental risk of annoyance, embarrassment, or oppression that cannot be effectively controlled simply by the court's model protective order. Anna Fan is a tax attorney. Next paragraph is very important. Okay. The court's model protective order permits disclosure of information exchanged in discovery to the parties and to fact and expert witnesses who sign an agreement that they will abide by the terms of that protective order and who agree to subject themselves to the jurisdiction of the court for purposes of enforcing that protective order. The willful violation of any term of the protective order is punishable by sanctions, including contempt of court. That provision is effective in the run-of-the-mill case in which the court can punish the violator with financial sanctions or order the return of confidential material. In an ordinary case, the party's primary interest is in the resolution of the lawsuit. The risk of disclosure is low, and if disclosure is made, it may be apparent. Moreover, the cost of the financial and other sanctions that the court might impose is greater than the benefit obtained from disclosure. The court's model protective order is not sufficient for the needs of these cases. These cases involve both business competitors and allegations of sexual harm. Discovery will necessarily include confidential and sensitive business and personal information. The risk of disclosure is great. Both the moving parties and the wayfarer parties have accused opposing parties of providing private, sensitive, or confidential information to the media for their own business and personal advantage in ways that cannot easily be traced. Several individuals and corporations on each side are in the business of public relations or media and have easy access to the press. The details of this case have been closely followed in the media, and each side has accused the other of litigating the case via the media. And where confidential information is not disclosed to the media, it may spread by gossip and innuendo to those in the tight artistic community in a position to do harm to one or the other of the parties, but in a manner that might not be readily and immediately detected. In the context of this case, there is good cause to allow several categories of information to be marked AEO. Okay. And then he's citing this case here, Stern v. Crosby, noting that discovery is not intended to be a vehicle for generating content for broadcast and other media. The disclosure of trade secret information in the form of business and marketing plans for projects other than It Ends With Us to a competitor who would have the ability to use that information to further its own business interests poses an incremental risk. Does that mean risk or incremental risk? I don't know. Of inevitable disclosure and use that is different from the risk presented when that information is disclosed to a lawyer representing the business competitor. Okay. Even if the competitor does not seek to misuse the information, it may be impossible to forget a client list or secret formula after having seen it. So we're talking about like the publicist stuff right now, guys. I guess Anna Fan, if you have any overarching thoughts on this, please share it with us. Like I said, Anna Fan is a tax attorney, so she understands this stuff better than I do for sure. Okay. So he's citing another case here. It says, it is very difficult for the human mind to compartmentalize and selectively suppress information once learned, no matter how well-intentioned the effort may be to do so. I mean, I get it. I've tried to forget so much of what I've seen about these people, and I can't. I can't unsee the lip biting, for example. Okay. The same protection is justified with respect to business plans for and of non-party clients, confidential strategies, and details about non-public creative projects. An author or creator of a creative project, including some of the parties to this case, may find it difficult in generating their own creative product to set aside information that they learn about the confidential works in progress of another party. Okay, setting a case here that says the mere fact that a party has access to a creative work and creates a similar work can lead to an inference of copying. The medical records of parties or third parties also may properly be marked AEO, albeit for somewhat different reasons. There is not the same risk that of such information wittingly or unwittingly being misappropriated by another party for their own personal benefit. So also, guys, I want to note this footnote here. It says, to be clear, business and marketing plans regarding It Ends With Us cannot be designated attorney's eyes only, given the central relevance of such information in this case. Medical records are information of the most intimate kind, and leaks of parties or third parties' medical information would be highly likely to cause a severe privacy injury. It may become necessary for such information to be disclosed to a party at some stage and depending on its contents. But given the accusations that the parties have made against one another and the challenges that the court would have in enforcing the protective order against persons other than the lawyers, an AEO designation is appropriate. So we're saying AEO is appropriate for medical records, right? Let me just... Okay. I mean, I kind of understand that, yeah. I can see that. Another AEO category in the protective order is security measures taken by parties or third parties. The Wayfarer parties have suggested that security measures are not relevant to this proceeding, but they have not raised objections to such information being kept AEO if it is disclosed. If such information is disclosed, it is highly confidential information with a significant potential for harm, and it may be properly designated AEO. And it says, medical records are always protected, so that's a given. And so far, Taylor Swift isn't protected. I can see that, yeah. Yeah. Guys, I'll get to the super chats at the end. I want to finish through the document, though. I do see you guys, though. I see it. Thanks. Oh. Donna, what's up? Just jumped in. Someone give me the Cliffs Notes. Oh, we're kind of... Or the Cliffs Notes, Jesus Christ. We're kind of still in the thick of it. I didn't read this before I came on the stream, so. Okay. Another AEO in the protective order is security measures taken by parties or third parties. So we went through that. The most challenging AEO category is, I think this is the interesting stuff, highly personal and intimate information about third parties, and highly personal and intimate information about parties other than information directly relevant to the truth or falsity of any allegation in the complaints in this case. This case involves allegations of sexual harassment and retaliation related to such harassment. Lively has asserted claims for damages in the form of emotional distress. Girl. Some information of a personal and intimate nature regarding the parties will inevitably have to be shared with persons other than the attorneys. The parties who are making the accusations or who are the subject of the accusations have a right to participate in the prosecution and defense of the claims. The attorneys have a need to consult with their clients. At the same time, however, it is in the nature of discovery that the net will be cast wide and that each side will be forced to disclose the other information of a sensitive, personal, and intimate nature that is not necessary or even relevant to the prosecution or defense of the claims. The point is even more apparent with respect to non-parties. So, like Taylor Swift. Those persons have not signed up for this lawsuit, but by virtue of Rule 45 subpoena power, they will inevitably be brought into it. And their personal information, which may be contained in the documents to be discovered, may well be the least centrally relevant to the determination of this action. In order to facilitate the flow of discovery, an attorney's eyes-only provision is appropriate for that category of information. Before the parties make an AEO designation, the protective order places on them the burden of determining that the information is not directly relevant to an allegation in the pleadings. So if they want the AEO provision, they have to first, I guess, prove or make their case that, this is something that shouldn't be seen by anyone other than attorneys. For the non-parties, no such burden is appropriate. They are entitled to designate all information in this category as attorney's eyes only, placing the burden to demonstrate the importance of the information for the prosecution or the defense of a claim on the counsel seeking to disclose the information to her client. I just like to listen to you, Lauren. Oh, thank you. I think, yeah, Anna Fan says, damn. Yeah, so this is, I mean, it's not perfect. It's not perfectly what everyone was hoping for, but we're gonna keep going here. All right. The court is cognizant of the right of the parties to assist counsel in the litigation. And then he cites a case that says, absent some specific concern, plaintiff will be permitted to assist his counsel in reviewing defendant's document production. The moving party's proposed AEO provision is not limited to the categories set out above, and would allow any material to be marked AEO if it is of such a highly confidential and personal, sensitive, or proprietary nature that the revelation of such is likely to cause a competitive, business, commercial, financial, or privacy injury. The language likely to cause a competitive, business, commercial, financial, or privacy injury is very broad. It mirrors that in the court's form protective order, which does not contain an AEO provision. In the context of this case, almost any information provided in discovery could be labeled as likely to cause a commercial or privacy injury. The court has narrowed the provision to stated that information may be marked AEO only if its disclosure is highly likely to cause a significant business, commercial, financial, or privacy injury. Moreover, at this time, such information should only be marked AEO if it fits into one of the categories enumerated in the protective order. If a disclosing party believes information which does not fit into any such category is of such a highly confidential and personal, sensitive, or proprietary nature that the revelation of such is highly likely to cause significant competitive, business, commercial, financial, or privacy injury, and therefore an AEO designation is justified, such part may apply to the court for modification of the protective order, consistent with the principles set forth in this opinion. I'm new here. What's the story with the bacon and robots? Guys, somebody fill around on the bacon and robots. Also, don't forget to like this stream for me while you're here. Do we have any other lawyers in the chat who want to chime in a little bit? Okay. We have a footnote down here. Let me take a look at that really quick. Although the moving parties cite other cases which have used similar broad language, in those cases the protective orders were generally entered unopposed. If the parties agree between themselves to limit certain sensitive information to AEO, there is little need for a court to police the precise boundaries of the category. All right. The Wayfarer parties argue that the entry of an AEO provision is premature, given that discovery has not commenced. They suggest that a conversation regarding AEO designation would be more appropriate once information arises that a party wants to designate AEO. They express concerns that the AEO provision will be overused and that the party opposing such designation will be required to consistently bear the burden of having information de-designated instead of the party seeking designation being required to support it in the first instance. To the contrary, entry of an AEO is intended to make discovery more efficient and prevent repeated disputes over the proper designation of discovery material. Although the Wayfarer parties suggest that the conversation should occur later, they have not stated any reason that security measures, medical records, or trade secrets would not be properly marked AEO. Okay. And then he's citing the docket here, something they wrote. It said, stating regarding medical records that we would fully intend to agree that that should be something that should be designated as highly confidential. So it seems pretty standard. He's also citing where they said security measures are not relevant to this proceeding, and noting that AEO provisions are typical in trade secret cases. So Blake isn't getting her way. Well, she will argue AEO on everything. I mean, that's probably going to get picky, isn't it? Yeah, let's keep reading because we got quite a bit to go here. We're halfway done. Clarifying now that such information may be designated AEO allows the disclosing party to provide it to the attorneys efficiently in response to discovery requests. Subsequently, if there is an issue with a particular designation, the receiving party may raise that with the court. If the disclosing party must confer with the opposing party and possibly come to the court each time AEO treatment is desired, this will delay discovery. The disclosing party will not be able to disclose that information, even to the requesting attorneys, until the request is resolved. If AEO protection is generally appropriate for a certain type of information, it does not make sense to require a new discussion every time a party wishes to designate such information AEO. It makes more sense for the receiving party to ask for de-designation in the rarer cases where the AEO designation is inappropriate. The court has made several other changes to the language of the proposed protective order in the interest of precision and clarity. Most of these changes were discussed at oral argument. The full protective order is attached as an appendix to this memorandum. The motion for the entry of the moving party's proposed protective order is granted in part and denied in part. And then we have the copy of the protective order down here. So this is the official protective order. This is what we landed on. One sec, guys. No, you're good, Anna. Okay. So let's go through this protective order and see what's different and what's, maybe not what they wanted. Anna says this is a win for Justin, in my opinion. I'm a tax attorney, but that's just my opinion. Okay, cool. All right. Any person subject to this protective order, including without limitation the parties to this action, their representatives, agents, experts, and consultants, all third parties providing discovery in this action, and all other interested persons with actual or constructive notice of this protective order, shall adhere to the following terms. 1. Any person subject to this protective order who receives from any other person subject to the order any discovery material, like information of any kind that's produced or disclosed pursuant to and in course of discovery, that is designated as confidential or attorney's eyes only pursuant to the terms of this protective order. Herein after, so he's going to call it confidential discovery material, shall not disclose such CDM, confidential discovery material, to anyone else except as expressly permitted hereunder. The designation AEO shall only be used for confidential discovery material of such a highly confidential and personal, sensitive, or proprietary nature that the revelation of such is highly likely to cause a significant competitive, business, commercial, financial, or privacy injury to the producing party. The following categories of information may be designated attorney's eyes only. A. Trade secrets, confidential business plans, marketing plans, and strategies for clients other than the parties in this litigation. Confidential business projects or leads on projects for clients other than the parties in this litigation. Confidential creative project or ideas other than those involved in this litigation. B. Security measures taken by parties or third parties. C. Medical information of parties or third parties. So far, that's like, these are like not really too interesting, but the last one is where it gets kind of different. Highly personal and intimate information about third parties, i.e. Taylor Swift, and highly personal and intimate information about parties other than information directly relevant to the truth or falsity of any allegation in the complaints in this case. So that means you can't just hide anything that is, relevant to the claims, like that's going to like prove, what they're saying. So basically, like, if it's not relevant to the lawsuit, if it's not relevant to what happened, then yeah, it makes sense that shouldn't be, that should be like more private, I guess. But they have to prove that it's like very likely to cause harm, a significant injury, not just like, oh, this might suck, That's how I put it in like elementary school terms, I guess. Anna says, you never want to piss off a judge. I'm still scared to go in front of a judge. I've seen attorneys shake in front of a judge. Hey, man, I would. So people are saying, Blake's team will attorney's eyes only all, but remember, they have to prove that it will, create a significant injury, like in a competitive sense, business sense, or privacy sense. So it's not going to be just like any text message you can't show or anything like that. I don't think that's kind of what I'm getting from this. But we'll read the rest of it and see. All right. I'm skipping lawyer fees for you. Okay. And the burden would be on Blake's side to prove it's AEO. Well, I'm not sure I totally understand that part. Maybe Anna could fill us in, but also I want to read over the rest of this just to get a better grasp on that, because it kind of sounded to me at one point like it was on them to say they should de-designate it, so that was confusing. But I'm going to keep reading. Okay. The protections conferred by this order cover not only confidential and attorney's eyes only information, but also any information copied or extracted therefrom, as well as copies, excerpts, summaries, or compilations thereof. The person producing any given discovery material may designate as confidential or attorney's eyes only such portion of such non-public material, the public disclosure of which is either restricted by law or will cause harm to the business, commercial, financial, or personal interests of the producing person, and or a third party to whom a duty of confidentiality is owed, and that consists of A, previously non-disclosed financial information, including profitability reports or estimates, percentage fees, design fees, royalty rates, minimum guarantee payments, sales reports, sale margins, confidential trading or investing information, and credit and banking information. So basically everything that bores me to tears. All right. B, previously non-disclosed material relating to ownership or control of any public or non-public company. C, previously non-disclosed business plans, product development information, marketing plans, trade secrets, creative ideas, films, scripts, projects, productions, entertainment activities, and other creative or artistic matters, client relationships, or communications regarding business affairs or contractual negotiations. And D, any information of a personal or intimate nature regarding any individual, including, but not limited to, non-public photographs, videos, or audio recordings of family or other personal relationships, non-public information regarding the identity and nature of personal relationships, medical, mental health, and or healthcare records, social security numbers, gosh darn, that's what I was looking forward to, or non-public contact information, including but not limited to telephone numbers, email addresses, physical addresses, or whereabouts, or code names for hotel use. They have code names for hotel use? God damn. If I understood this all correctly, this is all fair and good news for us and Baldoni, but really for us. We got kind of a mixed bag in the comments here. Some people are saying this might suck. Some people are saying it's reasonable. So yeah, I don't really think this is bad. And then I wanted to point this out, guys. If BL had a medical diagnosis that led to her actions, I think it's relevant, even if it's private and can cause significant harm. The thing is, she didn't. I'm just gonna say that. Like I've said my opinion on this before. I work in psych, so even if they're gonna try to do the mental health Hail Mary there, nah. No, there's no excuse for all this shit if like she really did make this stuff up. But also medical records, I believe medical records should always be kept private. Now if she was like schizophrenic and like totally out of her mind when all this happened, then that would make a little more sense, that it would be more relevant. But you could suffer from like postpartum depression or just like good old fashioned regular depression and anxiety and still not be a bitch. So I just don't think it's that relevant. That's just me though. Okay. Extracts or summaries of any information identified in A through D and any other category of information hereinafter given confidential status by the court. With respect to the confidential or attorney's eyes only portion of any discovery material, other than deposition transcripts and exhibits, the producing person or that person's counsel may designate such portion as confidential or AEO by 1. Stamping or otherwise clearly marking it in a way that won't interfere with legibility or audibility. B, producing for future public use another copy of said discovery material with the confidential information redacted. With respect to deposition transcripts, a producing person or that person's counsel may designate such portion as confidential or attorney's eyes only, either by A, indicating on the record during the deposition that a question calls for CDM or CDI, in which case the reporter will bind the transcript of the designated testimony in a separate volume and mark it as confidential information governed by protective order, or AEO, governed by protective order. Or B, notifying the reporter and all counsel of record in writing within 30 days after a deposition has concluded of the specific pages and lines of the transcript and or specific exhibits that are to be designated confidential or AEO, in which case all counsel receiving the transcript will be responsible for marking the copies of the designated transcript or exhibit in their possession or under their control as directed by the producing person or the person's counsel by the reporter. During the 30-day period following the conclusion of a deposition, the entire deposition transcript will be treated as if it had been designated AEO. Okay. So that means for 30 days after a deposition, it's all confidential. If at any time prior to the trial of this action, a producing person realizes that some portions of discovery material that she, he, or it had had previously produced without limitation, should it be designated as confidential or AEO, they may so designate by so appraising all prior recipients of the discovered material in writing, and thereafter such designated portions of the material will be deemed to be and treated as such under the terms of this order. No person subject to this protective order other than the producing person shall disclose any of the discovery material designated by the producing person as confidential to any other person whomsoever, except to A, the parties to this action, insurers and counsel to their insurers. B, counsel retained specifically for this action, including any paralegal, clerical, and other assistant employed by such counsel and assigned to this matter. C, outside vendors or service providers, such as copy service providers and document management consultants, graphic production services, or other litigation support, performing duties, services, okay, that counsel hire and assign to this matter, including computer service personnel, performing duties in relation to a computerized litigation system, as reasonably necessary, provided such vendors or service providers have first executed an NDA in the form annexed as an exhibit. Any mediator or arbitrator that the parties engage in this matter, or that this court appoints, provided such person has first executed an NDA. E, as to any document, its author, its addressee, and any other person indicated in the face of the document as having received a copy. F, any witness who counsel for a party in good faith believes may be called to testify at trial or deposition in this action, provided such person has first executed an NDA. And then we have here a footnote. It says, in the event the fact witness refuses to sign a copy of the exhibit, he or she may be shown confidential information only after on the record stating such refusal, and then being advised on the record the following. By order of the court in this action, you may not disclose in any manner any confidential discovery to any person or entity except in strict compliance with the provisions of this order, and if you do so, you may be subject to a sanction by the court. Depositions are usually summarized. I'm assuming those or the points of the depos are available for attorney-client consultation. All right. One sec, guys. I don't know, Lauren. I've been a real bitch before when my anxiety hits overload. Well, when you've done that, have you organized some weird plot for everyone else in your tiny little universe that you guys share to avoid them and then falsely accuse them of sexual harassment? I mean, probably not, Bren. I'm going to say no. But yeah. I mean, I hope not. Okay. G, any person retained by a party to serve as an expert witness or otherwise provide specialized advice to counsel in connection with this action, provided such person has first executed an NDA in the form annexed as an exhibit. Stenographers engaged to transcribe depositions, this court, including any appellate court and the court reporters and support personnel. With respect to discovery material designated AEO, such material shall only be disclosed to those persons identified in paragraphs 6, so what we just read, those people, but shall not be disclosed to the parties. Prior to any disclosure of any CDM to any person referred to in subparagraphs 6, D, F, G above, such person shall be provided by counsel with a copy of this protective order and sign an NDA. Said counsel shall retain each signed NDA, hold it in escrow, and produce it up to opposing counsel either prior to them being permitted to testify at deposition or trial or at the conclusion of the case. Any party who objects to any designation of confidentiality may at any time prior to the trial of this action serve upon counsel for the designating person a written notice stating with particularity the grounds of the objection. If the parties cannot reach agreement promptly, counsel for all parties will address their dispute to the court in accordance with paragraph 1C of this court's individual practices in civil cases. So if they object to an AEO or confidentiality designation, they kind of have to take that up with the court, I guess. A party may be requested to produce discovery material subject to contractual or other obligations of confidentiality owed to a third party. Within 2 business days of receiving the request, the receiving party subject to such obligation shall inform the third party of the request, and that the third party may seek a protective order or other relief from this court. If neither seeks a protective order or other relief within 21 days of that notice, the receiving party shall produce the information responsive to the discovery request, but may affix the appropriate controlling designation. Receipts of CDM under this order may use such material solely for the prosecution and defense of this action and any appeals thereto, and specifically, and by way of example and not limitations, may not use CDM for any business, commercial, or competitive purpose, including disclosure to the media. Nothing contained in this protective order, however, will affect or restrict the rights of any person with respect to its own documents or information produced in this action. Nor does anything contained in this protective order limit or restrict the rights of any person to use or disclose information or material obtained independently from and not through or pursuant to the federal rules of civil procedure, in keeping with the order by this court with respect to Rule 3.6. Nothing in this protective order will prevent any person subject to it from producing any CDM in its possession in response to a lawful subpoena, or if required to produce by law or by government agency, provided that such person receiving a request will provide written notice to the producing person before disclosure and as soon as reasonably possible. Okay. I'm skimming through some of this stuff that's just kind of like extra wordy and not really relevant to everything that people were looking to hear. Sorry, guys. All persons seeking to file redacted documents or documents under seal shall follow Rule 2H. No person may file with the court redacted documents or documents under seal without first seeking leave to file such paper. Okay. All persons producing CDM are deemed to be on notice that the Second Circuit puts limitations on the documents or information that may be filed in redacted form or under seal, and that the court retains discretion not to afford confidential treatment to any confidential discovery material submitted to the court or presented in connection with any motion, application, or proceeding that may result in an order and/or decision by the court, unless it is able to make the specific findings required by law in order to retain the confidential nature of such material. There is no presumption that CDM will be filed with the court under seal. The parties will use their best efforts to minimize such sealing. All right, guys, don't worry. We're getting there. We're almost done. me 1 sec. Okay. All persons are hereby placed on notice that the court is unlikely to seal or otherwise afford confidential treatment to any discovery material introduced in evidence at trial, or supporting or refuting any motion for summary judgment, even if such material has previously been sealed or designated as confidential. Any party filing a motion or any other papers with the court under seal shall also publicly file a redacted copy of the same via the court's ECF, which is the system I use to access these documents, that redacts only the CDM itself and not text that in no material way reveals the CDM. Each person who has access to discovery material that's been designated confidential or AEO shall take all due precautions to prevent the unauthorized or inadvertent disclosure of such material. If any personally identifying information like social security numbers, phone numbers, addresses, etc., passwords, I guess you can't just share everyone's passwords, exchange and discovery shall be maintained by the persons who receive such information and are bound by this protective order in a manner that's secure and confidential. In the event the person receiving PII experiences a data breach, she, he, or it shall immediately notify the producing person of the same and cooperate with the producing person to address and remedy the breach. Nothing herein shall preclude the producing person from asserting legal claims or constitute a waiver of legal rights or defenses in the event of litigation arising out of the receiving person's failure to appropriately protect PII from unauthorized disclosure. This protective order shall survive the termination of the litigation. Within 30 days of the final disposition of this action, all discovery material designated confidential and all copies thereof will be promptly returned to the producing person or, upon permission, destroyed. That could be fun. All persons subject to this protective order acknowledge that willful violation of this protective order could subject them to punishment for contempt of court. This court shall retain jurisdiction over all persons subject to this protective order to the extent necessary to enforce any obligations arising hereunder or to impose sanctions for any contempt thereof. Okay. And then they have to sign this, basically agreeing to what the judge laid out in the protective order. So, hey, Zach, what's going on? Thanks, mods, for being here. I just got here. Please summarize when you're done. Oh, man, I have to go back to work. Let's see. And I might, I'll go over this with Omar, the tilted lawyer who comes on my channel a lot, and I go on his. And we will break that down in a way that he will talk about the legalese and kind of make it make sense. And I will make fun of him. So, yeah. Dang, you're quick. I know, man. I keep telling you guys. You don't need court listener. It was down all day yesterday. I'm faster. It's fine. Let me read these really quickly, guys. I got here late, but I haven't heard anything upsetting. No, I don't think it's bad. Only the listed categories will be designated AEO. That's correct. And guys, I'm going to post the link to this document. I'll put it in the description of this video after the stream is over. Not the description. I'll put it in the comments and pin it. And then also I will put it on Twitter and elsewhere. So let me read these real quick. I think I already read this one, but I'll read it again anyway. Stephanie, thank you for the 5. Always the first to report. Yes, ma'am. I work very hard to get to things as quickly as possible, even if it's in the middle of my workday. Luckily, I work from home and I'm flexible. I get to take, not physically flexible. Come on, guys. I'm flexible in that I get to take my breaks when I want. So I wait until I have something that I need to do. Lily May, thank you for the $3. Thank you, Lauren. No, thank you, Lily May. Eurojin, thank you for the 12. Thanks for helping us understand the legal jargon after reading the information. Well, thank you. I appreciate it. Omar obviously does a lot better of a job on that than me. But, yeah. KS, thank you for the 5. We'll be going over the Town podcast with Brian Friedman that was just released later today. I will. I'm waiting for a specific reason. And I can't say anything yet. Because I have to get confirmation, and I've reached out to somebody for confirmation, but before I do that, I want to wait and see if I hear back, because something odd is going on with the docket. Thank you for the $5. Thanks, Lauren, Anafan, tax attorney. Thank you, Anafan, tax attorney, for joining us, as always. Victoria S., thank you for the super sticker, the $2. I really appreciate it. Lauren Crampsey, thank you for the $5. It's kind of a cool last name. With love, attorney's eyes only. Oh, shit, you're going to have to sanction me. I just read this out loud, and I put it on the screen for everybody to see, and it was supposed to be confidential. So, Traveler Landed, I look forward to your live streams. You've got a good vibe. Does your psych experience lend in law fair knowledge in that realm? So, not really. I mean, in terms of like how mental health works in the courts, what incompetence is, legal incompetence is, and what can and cannot be used as a valid excuse for behavior and shit like that, in that sense, yes. My master's degree was actually in criminology. So I do have a little bit of knowledge of the justice system, but when it comes to these court filings with these big legal jargony paragraphs and words, sometimes it's just really hard. I was telling some people the other day, I don't know if it was on stream or not. I had applied to law school a long time ago, and I got in, but I didn't go because we don't have one in town, and I was tired of living far away from home. I had been in college in Arizona, and then I went to Tallahassee for grad school, which was not bad. But then I also went to New York to do some grad school work in forensic psych. And then I was just like tired of being away from home. So I moved back. But now, like I said the other day, they just opened a fucking law school here in Jacksonville. So I'm like, well, if they get accredited, I might have to think about that. But it sucks because I'm already back in school for something else, right? For digital media. So, man, like what the heck is that? Life is weird, dude. Zach, thank you for the $5. I was just going to caution Lauren for letting butter lick her face really nasty. Then I realized Lauren isn't too particular whose tongue is on her. Zach, I don't know where you're getting your information, but it is 100% correct. Yes, guys, please like this stream for me if you could. I would appreciate it. It would help my channel out a lot. Like I said, in the next 7 days, so like all the responses to these complaints, like to Justin's admitted complaint, to Blake's complaint, I think, the response to the publicist's complaint, just like all the responses to these complaints are apparently due on March 20th. So I expect to see a lot of stuff popping up on the docket in the next week. And I will keep my eye out. And obviously, you guys know I like to get to it as fast as possible. So, yeah. Give me 1 second here. I was going to see if I could find... No, that's not it. I wanted to raid somebody, but nobody's really live right now, are they? Recovery Addict is. He's going to get tired of me. Let's do it anyways. All right, guys, send my love to Recovery Addict. I'm redirecting you to his stream. I will be back later, either tonight or tomorrow. I'll let you know. I'll post something on my YouTube channel and on Twitter, and on Patreon. So, yeah. All right, everybody. Thank you. If anybody does do a little summary and they want to put it in the comments, feel free. Bye, guys.